Magandang araw. This is our discussion of module number 10 for BOM 026. So here is our lesson title, Extinguishment of Obligation Part 1, Payment or Performance. So Part A pa lang ito, meaning to say, hinati yung payment or performance sa dalawa. Now, this is our lesson objective. At the end of this module, I can define payment, identify the persons from whom the creditor must accept payment and person to whom payment shall be made. Explain the effects of payment by a third person and state the special forms of payment. Here is our productivity tip. As humans, it is normal to feel tired and run down. Difficult times will stretch us thin. We must collect our courage and bravery and do our task regardless of how we feel. Remember the verse in Philippians 4:13, I can do all things through Christ who strengthens me. Keep fighting for your dream. So bilang mga tao, normal lang na makaramdam tayo ng pagkapagod at pagkahapo. Siyempre, sa mga ganitong pagkakataon, kailangan ipunin natin lahat ng lakas ng loob natin at lahat ng tapang natin para mapagtagumpayan natin ang mga bagay kahit na hindi maganda yung pakiramdam natin. Laging tatandaan na lahat ng bagay ay kaya niyong gawin sa pamamagitan ng Diyos na nagbibigay sa atin ng lakas. So here is our lesson preview. Okay, para hindi nyo makalimutan yung extinguishment na word. Ayan, fire extinguisher talaga yung ginamit sa picture. But anyway, during the first period, you learned about the general provisions of the law on obligations and contracts, the nature and effect of obligation, and the different kinds of obligation. Here, in the second period, we will focus on the modes of extinguishment of obligation kasi marami yung modes na yan. So, una na nga, yung payment and performance. Okay. So, Merriam-Webster Dictionary defined extinguish as to bring to an end. The modes of extinguishment of obligations are basically the causes which put obligations to an end. Kaya pag sinabi nating extinguishment of obligation, ito yung mga pamamaraan kung saan natatapos ang obligasyon ng isang debtor. The law on obligations and contracts specifically provided the pertinent provisions relating to the six modes of extinguishment of obligation. And these modes, however, are not the only causes of extinguishment of obligations. Some modes of extinguishment of obligations are governed by other laws under the Civil Code. So, bagamat may anim na binanggit ang law on obligations and contracts na modes of extinguishment of obligation, hindi ibig sabihin ay anim lang talaga ang modes ng extinguishment ng obligation, ha? Nagkataon na sa law na ito, na pag-aaralan natin, anim yung specifically provided. Ngayon, in this module, please prepare to learn the first mode of extinguishment of obligation, which is by payment or performance. Okay, so activity 1, of course, you need to pause this for a while and please do the what I know chart. Welcome back. Gawin nyo talaga yun, ha? Okay, so here is our main lesson. Payment or performance. So Article 1232, payment means not only the delivery of money, but also the performance in any other manner or of an obligation. So sabi dito, as you can see from the legal provision above, in legal parlance, payment also means performance. Ano raw? Tama ba ng dinig at intindi kayo? Oo. Sa legal parlance, o in the legal world, ganyan na, ang payment and performance are used synonymously. So, tama kayo ng intindi. Payment and performance is the same in the legal parlance. So, moving on, the debt is considered as paid if the thing or service has been completely delivered or rendered. So, when debt is considered paid, kailan daw ba natin kino-consider na ang isang utang ay bayad na? First of all, let us understand what debt means in relation to the law on obligations and contracts. So, do you still remember the meaning of obligation? Recite nyo nga dyan kung talagang alam nyo pa. Article 11, ano na nga ba yun? According to Article 1156, an obligation is the juridical necessity to give, to do, or not to do. Ayan. Very good kung nasabayan nyo ako. O binasa niyo lang to. Ito pala ayan. So, therefore, in relation to the definition provided by law, a debt may consist of an obligation to give, a debt may consist of obligation to do or not to do. So, when is debt considered as paid? Ayan. Sabi rito, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered as the case may be. Kailangan ay completely delivered or rendered. So read the above article once more. Understand that the general rule is that a debt is only considered as paid when the thing or service has been completely delivered or rendered. So ulit, kailan nga ba kinokonsidera ng isang utang ay bayad na? Kapag what is the most vital terminology here? Yung salitang completely. Ayan. Completely delivered or rendered. Okay, so, however, there are exceptions to this general rule. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Kapag daw ang isang bagay substantially performed in good faith, o diba, iba yung completely delivered and rendered sa substantially performed in good faith. Pag sinabi kasi natin na completely, talaga namang kumpleto as in. Pag sinabi natin substantially, okay, so, alam ko naman na sa accounting world ay na-encounter nyo ang word na substantial compliance. So, ibig sabihin nito na ibigay naman yung sabihin natin, yung isang bagay, however, parang may kulang lang na konti. Pero despite that fact ay good faith naman siya. Ibig sabihin, kapag sinabi natin good faith, no, kumbaga, wala siyang intensyon, puro yung kanyang intention na mag-comply, wala siyang masamang iniisip o intensyon. Ayan. So, bagamat po pwedeng negligent siya, ay hindi naman niya sinasadya yung mga bagay, yung mga ganong eksena pag sinabi nating good faith. Now, kapag ka may substantial performance in good faith, i-consider na rin yung thing as delivered. Kaya nga lang, syempre, ima-minus natin yung damages na nasuffer ng obligee. Okay. Now, moving on. Another exception is that when the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Okay. So, anong ibig sabihin nito? Kapag daw yung creditor or obligee, inaccept niya yung performance kahit alam niya na may kulang, kahit na alam niya na parang may mali, tas hindi naman siya nagprotesta, hindi naman siya nag-object. Anong sabi rito? The obligation is deemed fully complied with. Ipagpapalagay na fully complied with na ang obligation or as if completely delivered or rendered. So again, what is your general rule? Okay, the debt is understood to have been paid if it has been completely delivered or rendered, and we have two exceptions to the general rule. Okay. Yung creditor ba, kani-kanino ba siya dapat tumanggap ng bayan? In English, persons from whom the creditor must accept payment. The creditor is bound to accept payment or performance from the following. Pag sinabi nating bound, whether he likes it or not, he needs to accept the payment or performance of the following person. First is the debtor. Next is any person who has an interest in the obligation. Sino-sino ba yan? Example, yung guarantor at saka yung surety, And then, a third person who has no interest in the obligation but there is an agreement that he can make payment. Ang point natin dito, kasi alam nyo, yung creditor, hindi pwedeng pilitin ng isang tao na wala namang kinalaman sa obligation o nang basta kung sino-sino na lang na tumanggap ng bayad. So halimbawa, si A may utang kay B. Okay, sino yung creditor doon? Si B, di ba? Ngayon, ako gusto kong bayaran yung utang ni A. Pwede ko bang pilitin si B na tanggapin yung bayad from me? The answer is no, hindi ko siya pwedeng pilitin. Why? Because according to this particular particular provision of law on obligations and contracts, ang creditor lang ay must accept payment or bound to accept payment. Kanino lang? Kay debtor, dun lang sa person who has interest in the obligation, o kaya sa third person na wala namang interest sa obligation, pero may agreement naman na po pwedeng magbayad. So, dahil ako, third person ako, wala namang agreement na pwede kong magbayad, then hindi ko po pwedeng pilitin si B na tanggapin o tumanggap ng bayad mula sa akin. So, sana, gets nyo yun. Ha? Okay. So, ayun lang. Okay. So, eto medyo technical. Di ba, example natin kanina, si A may utang kay B. Si B yung creditor, tama? Tapos ako yung third person. Gusto kong bayaran yung utang ni A. Pwede ko bang pilitin si creditor na tanggapin yung bayad mula sa akin? Ang sagot doon, hindi ko pwedeng pilitin. Pero tanong, ulit, pwede bang tanggapin ni B yung ipinabayad ko kung halimbawang gusto niya? Yan. The answer is yes. So, anong point natin dito? Hindi ko pwedeng pilitin. Pero pag gusto niya, pwede naman akong magbayad. Kung gusto lang naman niya. Okay? So, more on this. Usapan natin effect. Tignan nyo yung drawing mo. Na may third person, pinipilit magbayad. Langaw yung wallet. Okay. The third person, pinipilit magbayad. O tingnan si creditor, naka-thumbs down. Bakit? Hindi niya pwede pilitin. Pero kung gusto ni creditor tanggapin, pwede naman. So, what if tinanggap niya? Usahin natin to. Effect of payment by third person. But the creditor is not bound to accept payment or performance from a third person who has no interest in the fulfillment of the obligation unless there is an agreement. O, alam na natin yan. A third person who has no interest in the fulfillment of the obligation is just someone who wants to pay the obligation out of nowhere. We may never know for sure what motivates him to pay for someone else's obligation. The point is, the third person cannot force the creditor to accept his payment. The creditor can't be forced, but it does not mean that the creditor is prohibited from accepting the payment. The creditor can accept payment if he wants to. So let us say, ito na yung gusto niyo malaman. Let us say, tinanggap ni creditor yung bayad from the third person. Anong consequence nito? Ayan. Of course, the debtor will now have to pay the third person for the payment he made insofar as the payment has been beneficial to the debtor. Siyempre naman, ako to, di ba? Kanina ako yung third person. Siyempre naman, binayaran ko yung utang ni A. Tinanggap ni B yung bayad ko. So, natural na benepisyohan naman si A. Kailangan din naman, bayaran niya ako sa halaga na benepisyohan siya. So, kung 100 yung ibinayad ko dun sa utang niya, 100 yung utang niya, binayaran ko ng 100, bayaran niya din ako ng 100. Okay. So, ang sabi rito, may bago tayong terminology, ha? Listen very carefully. But whether or not the third person will be entitled to subrogation will depend on whether the debtor consented with the payment. Okay. Okay, may bagong eksena dito. Pero ano muna ba yung subrogation? Subrogation is where the third person acquires not only the right to be reimbursed for what he has paid, but also all other rights which the creditor could have exercised pertaining to the credit. Let us say that the debtor mortgaged his lot for the purposes of obtaining the loan. Subrogation will give the third person the right to foreclose the lot mortgage in case of non-payment. So imagine niyo kung si A may utang kay B at isinangla ni A yung kanyang lupa, okay, o ipinrenda ni A yung kanyang lupa in consideration of the loan. So may prendahang nangyari ng lupa, no? May sanglaan nangyari. Tapos di ba binayaran ko yung utang ni A kay B. Ayan. Tanong, may karapatan ba ako na kuhanin yung mga papeles o dokumento ng sanglaan ng lupa? Ayan. Depende. Depende kung pumayag si A na bayaran ko yung utang niya. Kasi iba ang magiging consequence kapag si A, bawa, hindi niya alam, binayaran ko yung utang niya. Iba rin ang consequence kapag nagpaalam ako kay A at pumayag siya na bayaran ko yung utang niya. Iba pa ulit ang consequence kapag nagpaalam ako kay A pero hindi siya pumayag. O, di ba, alam niya pero hindi siya pumayag. Nagpaalam ako kay A pero hindi siya pumayag na bayaran ko yung utang niya. Iba pa ulit yan, ha? So, nakita niyo yung tatlong eksena na yan. Okay, pag-usapan natin. Though tatlo yung eksena, pagpapalagay natin na yung payment made without knowledge o kaya payment made against the will of the debtor. The third person may recover from the debtor only insofar as the payment has been beneficial to the debtor. So halimbawa sa eksenang ito, si A may utang kay B. Hindi naman sabihin makulit para lang hindi kayo mawala sa kwentuhan. Si A may utang kay B at isinangla ni A ang lupa niya kay B para mapautang siya ni B ng 100,000. Ngayon, binayaran ko yung utang ni A nang hindi niya nalalaman. 100,000. Magkano lang ang pwede kong i-recover kay A? 100,000. Tama? Pwede ko bang kuhanin yung mga dokumento ng sanglaan ng lupa? The answer is no. What if sinabi ko kay A, babayaran ko yung utang mo, ako na bahala. Sabi ni A, ayoko nga. Pero makulit ako, binayaran ko pa din. Tanong, magkano ang ibabayad o pwede ko ma-reimburse kay A? 100,000. Another question, pwede ko bang kuhanin yung mga dokumento ng sanglaan ng lupa? The answer is no. Bakit? Nagpaalam nga ako pero hindi ako pinayagan. You see the consequence? Iba ang kwento kapag merong payment na merong consent ni debtor. Ito siya ha. Huwag kayong mawala sa kwentuhan natin. Sarap yung chikahan. Oh. Payment made with the consent of the debtor. Then, the third person shall have the right of reimbursement and subrogation. Ayan. Yung mahiwagang subrogation na yan. Mare-reimburse na ako. Pwede ko pang kuhanin yung mga dokumento ng sanglaan ng lupa. Bakit? Kasi the payment was made with the consent of the debtor. So halimbawa, nakuha ko na yung mga dokumento, subrogated na ako na yung bago niyang creditor. Hindi nakabayad si A. Pwede ko bang i-foreclose yung mortgage? The answer is yes, because I have all the rights pertaining to the creditor. So that's the difference dun sa mga consequences ng mga iba't ibang senaryo na ibinigay ko sa inyo. Kapag meron kayong na-miss o hindi naintindihan, yun ang ganda ng video discussion. Tama naman kayo dyan. I-rewind nyo lang. Ha? Okay. So, person to whom payment shall be made. Kanino naman, ko naman yung debtor, kanino ka naman ba dapat magbayad? Siyempre, obviously, kailangan magbayad ka sa creditor. Sabi number 1, creditor. Pagka natsugi naman ang excuse me. Video discussion pala to. Kailangan maganda yung mga terminology ginagamit. Kapag halimbawa naman, in case na namatay si creditor, kanino ka magbabayad? Ang lagay ba ay tabla na? The answer is no. Kailangan magbayad ka sa successor in interest. O kaya, pwede ka rin magbayad kay any person authorized to receive it. Ayan. So, effect of payment to an incapacitated person and to a third person. Halimbawa, ikaw si debtor, may utang ka kay creditor, nagpunta ka sa bahay nila, madaling-madali ka, hindi nasabi sa'yo ng katulong dun sa may bahay o bantay ng bahay. Sabi sa'yo, wala po dito madaling-madali ka, iniwan mo yung pera. Tanong, is the payment valid? Ala, it depends. Bakit it depends? Kung yung taong bahay doon authorized person to receive it, okay lang. Bakit? Kasi included siya sa person to whom payment shall be made. Authorized na may tao. What if anak lang yung nandun, tapos minor de edad, nagbayad ka? Tanong, valid ba yung payment mo? Pag-usapan natin yan. The general rule is that, ito tayo ha, The general rule is that the debtor must only give his payment to the above-mentioned person. Otherwise, the payment is not valid. O kayo na sumagot sa tanong. May bata, anak. Anak nung pinagkakautangan mo. Bantay ng bahay. Nagmamadali ka, dun mo inabot yung bayad. Minor de edad. Question. Valid ba yung payment mo? Ikaw na sumagot. Based on this, sa pinag-aralan natin. What do you think? O di ba parang hindi? Kasi nga hindi talaga. So, hindi valid yung payment mo. So, ano naman ngayon kung hindi considered na valid yung payment? Na mo ha, nilabas mo na yung pera mo. Nabigay mo na, naiabot mo na, pero hindi valid yung payment. Ano ang consequence pag hindi valid ang payment? Sabi rito, the debtor may be compelled to pay again. Yung may mga exception naman sa rule. Hindi naman ito masyadong grabehan sa pagka-strict. Ha? Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Incapacitated yung person. Incapacitated to administer his property. O minor de edad ang pinag-uusapan dito, ha? Incapacitated to administer his property. Valid naman kung naitago niya. Pero hindi niya naitabi at nawala at hindi niya maituro kung saan niya nilagay. Is the payment valid? The answer is no. Can the debtor be compelled to pay again? The answer is yes. O diba? Ang saklap. Alright. So, halimbawa naman, 1,000 pesos halimbawa ang pinag-uusapan natin dito. Payment to an incapacitated person pa rin. Dito pa rin tayo sa una. Tapos yung 500, pinang-Jollibee niya. Yung 500, nawala. Tanong, valid ba yung payment mo? Well, insofar lang doon sa naging beneficial doon sa incapacitated person. So, dahil pang-Jollibee naman niya yung 500, nabusog naman siya. So, para ka na rin nagbayad ng 500 pesos. Eh, nawala another 500. Magkano lang yung valid na payment? 500 pesos na. Can you be compelled to pay the another 500 pesos? The answer is yes. Ayan. So, anong lesson learned? Okay, magbayad lang sa mga tao kung saan dapat tumanggap ng, magbayad lang sa mga tao na may karapatang tumanggap ng bayad. Okay, next. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Okay, so. Nagbayad sa third person na example sa bahay pa rin example natin. Example lang naman ito. Ang nasa bahay katulong. So, ang bayad ay 1,000. Nagbayad ka ng 1,000 doon, inabot mo lang. Wala lahat sila kasi katulong namin nasa bahay. Ang galing gumawa ng story. Kaso, dumating yung namumutol ng tubig. Hindi mo pala sila nagbabayad ng tubig. So, ang ginawa ng katulong, kahit di pa siya nagpapaalam sa mga amo niya, yung ibinayad mo, na 1,000, yun yung ibinayad niya doon sa, ano ba yung bayaran ng tubig natin? CCW, di ba? O yun doon sa, water district, tama na. So, yun yung ibinayad niya sa water district. Ayun, hindi naman sila naputulan ng tubig. Anong point dito? Is the payment valid? The answer is yes. Insofar as, sabihin natin na 900 pesos yung ibinayad niya sa tubig. Tapos yung 100 pesos, ikinain lang ng third person. Yung yung binila lang niya gusto niya, sorry. Binila lang niya gusto niya. O, ipapaligyan natin na wala. Ayan. Nakalagay kasi dito, payment made to a third person shall also be valid insofar as it has redounded to the benefit. Bumalik dun sa benefit ng creditor. Na-beneficiahan yung creditor sa madaling salita. Yung pantubig ng binayaran para hindi maputulan. Is that beneficial to the creditor? The answer is yes. So, amounting to 900 pesos. Pumari na lang yung 100 pesos ay hindi siya ang nakinabang. Can you consider it as part of the valid payment? The answer is no. So, can he be compelled to pay another 100 pesos? The answer is yes. Yan. Yung tanong naman, can he be compelled? Oo lang naman. Pero, pwede din naman niya habulin yung katulong na, hoy, ikaw, ibinayad ko sa'yo. Ibang usapan naman yun. Ha? Ibang usapan yun. Pero, syempre, pwede naman yung habulin yung katulong na, oy, ikaw, itinakas mo yung 100 pesos ko. Amin na yan. Kaya lang, ikaw yung maghahabol dun sa katulong. Hindi yung ang mamumroblema, yung creditor. Ayan. Next, payment made in good faith to any person in possession of credit shall release the debtor. Ano ba yung possession of credit? And a person in possession of credit, alam mo mga example nito, halimbawa yung mga promissory notes, ganyan. Okay? So, halimbawa yung promissory note, napulot lang niya, hindi kanya talaga. So, you never know. Tas, hindi naman na kasi uso talaga promissory note ngayon in fairness. So, yung promissory note, halimbawa lang, nag-exist pa, tapos napulot halimbawa ng isang tao, tapos pinresent niya sa'yo, ikaw yung debtor, tapos binayaran mo naman dahil ang paniwala mo ay, okay? Ang buong paniwala mo ay kanya na talaga yung promissory note na yun, na-endorse na sa kanya. Then, this kind of payment made in good faith to any person in possession of credit shall release the debtor. It will be considered as valid payment. So, I hope na naintindihan niyo itong mga exceptions to the rule. So, when payment to the creditor not valid, Article 1243, payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. Kapag inutusan ng korte yung debtor na huwag magbayad, okay? Pero nagbayad pa rin siya, yung payment na yun will not be considered as valid. So when we say judicial order, it means the court has ordered the debtor to retain the debt or to not pay the creditor. But if the debtor disobeyed the order of the court, this payment will not be considered as a valid payment. So we have the special forms of payment. Ito yung aaralin sa next module. Itong special forms of payment, the shown in payment, application of payment, payment by session, tender of payment, and consignation. So see you in the next module.